court said that income tax department can completely go through a different rigmarole and need not come into the 391, 394 process. The same way, for some other subsidiaries, we handled another merger of the same Vodafone group connected to the same transaction in Chennai. While doing so, the income tax department came here and objected for the other subsidiaries. So when they objected, the High Court took a view that no, it's relating totally to third party, maybe a wholly owned subsidiary, but still completely different. So therefore, 394A does not permit you to come in and object, and there's no provision of law for objecting. So now they want to expand it and try to dilute it. Now, how far a circular can get over, or rather get judicial recognition, again we'll have to see. I have at least 3 judgments by the High Court and Supreme Court which says the department circular, particularly DCA circular, is only advisory and not a mandatory one, right? From the revaluation of reserves to issue bonus shares, where the Supreme Court said in the Peerless case, and also the Madras High Court decision on generally how a Department of Company Affairs circular has to be seen. It's only advisory. But in regard to mergers, the courts have generally gone by the department's view because they feel that mandatorily 394A gives them a right to place certain representations before the court. So under that principle, this particular circular will not be watered down, is what is my view. So there's some new development just about a week back, so which is relevant insofar the present mergers and the concepts which are going to come in the new provisions. Then the next one is with regard to, they're trying to bring about recognition of the reduction of capital exercise. Presently under the new act, we ensure that a reduction of capital and a compromise or a merger or demerger is also clubbed together. When they club together, there is a particular rule 85 in the Companies Code rules which say that if it's involving reduction, you will have to separately follow the process of 100 to 103, whatever, for the purpose of sanction under the present act. But courts in the last 20 years have diluted it, whittled it down, and have said that now you can try to combine and make a composite scheme of reduction and also a merger or a demerger or an arrangement. That judicial pronouncements have got recognition through this provision of 232, where if it's a reduction of capital, you can go through without going through section 66, which is the old section 100. Next one. The CDR mechanism. This comes in for the purpose of restructuring capital or a debt. The CDR mechanism was itself born out of the failure of 391, particularly regarding scheme of arrangements. The courts were taking a long time to sanction the scheme of arrangements. 391 is where you went for a scheme relating to class or creditors or class or members. So if it involved conversion of debt into equity or equity into debt to ensure that the companies came out of their problems, there were a lot of objections in the courts, and therefore the whole thing became a litigation. After that, file appeal to Supreme Court. So it was taking 4 or 5 years. So the Reserve Bank of India also wanted to come out with a mechanism where the banks could get faster redressal of either using the Securitization Act and going through. Apart from that, if a company also felt that it wanted to restructure faster with the banks and it saw a revival proposal, they brought about the CDR mechanism, which we know. The CDR mechanism is also now coming into the Companies Act itself, and how far, again, the time is going to be, we'll have to see, because the whole mechanism takes about 6 months at least. So 75% secured creditors in value, if they can bring about this, and with this they have also brought about the valuation rules separately and also a complete procedure as such. This is to implement it through the tribunal process. The notice of the meetings, procedurally, 393, the present section, it does not find its place fully here. It is slightly different. Here they just also enumerate what all the notice should contain, the details of the compromise, the valuation report. Till now, we don't supply the valuation report. We at least say that it is available for inspection at the venue of the meeting. Whether we do it or not is the second part. Now that has to go through with a complete valuation of both the tangible and intangible, explaining the effect of the scheme on the promoters, non-promoters, debenture holders, and all the categories of persons. And the word additionally found is also regarding debenture holders also. So presently, unless the debentures holders interest is involved, 393(2) said notice need not go to the debenture holders. But here it says that debenture holders automatically get a notice of the meeting irrespective of whether their interest is involved or not. That's a major change. So debenture holders also come to be involved in a scheme which does not concern them. The most interesting section according to me is this 230 clause 5, which I was just mentioning about 5 minutes back regarding the recent circular also. Notice to all the authorities whomever they feel. Now, this is a bit vaguely worded too. You would find on the first line of the provisions, if necessary, in italics, though that's a bit innocuous, but when we read with the rules and the section, I'm able to at least see a particular process. It doesn't say whether we have to send it or the tribunal has to send it, but the form is given in the rules. The form appears to be that the notice is pursuant to an order of the tribunal dated so and so, considering a scheme, and thereafter a notice is to be issued to, it says, with all the departments oblique. So therefore, it appears we have to infer that tribunal will, while hearing, will decide to which departments the notice will go. I take inference because of the word if necessary, because you and I cannot decide to which department to send. We don't want to send it to any department. That's the first thing. The second part of it is, even if we send it, can we choose departments? A corollary view is in regard to class meetings. When we convene class meetings, we know that equity shareholders preference or whatever shareholder category, and creditors meaning secured, unsecured, or trade or deposit holders or whatever different class of creditors. It is left to the companies to segregate the classes. So when it went for interpretation before Supreme Court, in the Meher Mafatlal's case, the Supreme Court said classes have to be identified only by the company, because they are the ones who are calling the meetings, and it's prior to the sanction. Therefore, you decide which class is a separate class or a consolidated class. But the obligation of failing to call a class meeting is also on you. So if you have not called a class meeting, that scheme will be completely dismissed on that ground of non-classification of a proper class. Similarly, it doesn't find itself here that we can choose and send. It appears as if that the word if necessary means not we, but the tribunal. So I interpreted that the tribunal alone will have a right to choose to which department to send it to. Now, income tax department may be standard, but if it's a telecom company, to the telecom department, or if it's a, let's say, some kind of pollution related business, to the pollution department or whatever, and up to Competition Commission if it is too big a merger, if they feel. But if it was too big, anyway it is going to go to Competition Commission automatically, because thresholds are very high, and if you go above the thresholds, automatically goes to the Competition Commission. Below the thresholds, why should I go, could be a question I ask, but if the tribunal wants to send, because section provides so, it's a very wide power. So that being the case, this section is the one which is going to determine whether a merger is first of all going to go through or a demerger is first of all going to go through. If all these departments get the notice, and as I told you, we lawyers always find ways out. We don't find ways for a solution. So the first thing is, okay, 30 days time is given for a deemed consent. If 30 days time you don't hear, automatically the tribunal goes on with the second stage of the process as contemplated in the provisions. But assuming for a moment a lawyer of the department comes and appears and says, look, we would like to place our submissions on the scheme, we have to file certain objections, so kindly grant us time. Now, tribunal in its inherent powers therefore finds that it is getting represented before them. Technically, 30 days deemed consent is not to say that they can support or object to the scheme. If you don't come within 30 days, it's deemed as consent. The corollary is, if you come within 30 days, then means you have to hear their objections whenever they're going to bring. So naturally, every authority would like to come and take 4 weeks, 6 weeks, or whatever. So the moment the authority comes before the tribunal, then automatically the provision is kind of stunted. I won't say nullified, stunted, to say that they will have to be heard thereafter. So we are going to find not the creditors or the members opposing our scheme. We are going to find new authorities who are going to come and place their submissions, particularly I would say the tax authorities or other statutory authorities which are relevant to your business activity. And this is going to regulate, or I would say restrict, a large amount of transaction work in the form where it was only procedural. This is going to become more litigative or more adversarial rather than non-adversarial, which is present in High Court right now. Except the Department of Company Affairs, which comes in places, no one troubles, and if no one comes, the court sanctions the scheme, and an effective time of a merger or demerger is not more than 3 months. So this particular provision according to me. If read, A, tribunal hears it, B, it decides to which department it wants to send. It doesn't mean that the sections, whatever authority is contemplated, it sends to everyone. It decides which one to send by virtue if necessary, and after that the notice format says that we will have to prepare it and send it. For the last portion of the notice, why I am inferring is, if you read it along with Form 5 and particularly Form 6 of the Companies Code rules, Form 5 is the one which goes on the advertisement on mergers which you see in the newspapers. Form 6 is the one which goes to the registered office of the company and to the Department of Company Affairs that a scheme has been filed in court. If you have any objections, kindly come and place it. So this draft rules, the form, and the form in Form 5 and 6 virtually correlate to show that it is a notice where we prepare after the courts have ordered it. So I am inferring after the tribunal has ordered it, we can prepare based on the order of the tribunal and send it. So this is going to be the most important part of the whole restructuring exercise according to me, or the heart of the restructuring exercise, to decide whether you can have the scheme or not, or whether it's going to take a shorter time or a longer time. Then mode of conduct of meetings. The section has completely, I would say, missed out a particular area, which is the dispensation of meetings. As of now, we have a benefit which you're losing unless the tribunal reads it otherwise. The High Court has the power to do what it wants. Whether the tribunal can do so, we'll have to wait and see. Whenever we have few shareholders of 5, 10, 20 or whatever, we get their consent affidavits and don't hold meetings of them and get what is called as a dispensation. Creditors goes by each state. Some states, like I would say the Bombay High Court or the Delhi High Court, they even fix a cap for the unsecured creditors. Above 5 lakhs hold a meeting, above 25 lakhs hold a meeting of unsecured, and segregate into categories. In our High Court right now, we only get the consent of the secured creditors and do not go with unsecured creditors. Some judges who came said at least issue notice to the unsecured creditors. So there's no hard and fast rule in regard to creditors meeting. Now here they said that if you want to dispense with creditors meeting, 90% will have to give consent. No problem. As of now, I'm getting already 100%. And unsecured creditors, if you want also, I can get it, because in reduction of capital presently, we try to get their consent. But unfortunately, they did not provide for a members meeting. The section does not contemplate that a members meeting could be dispensed with. So we go back to a worse position from where we are now. At least the High Court evolved a procedure of, I would say, judicial pronouncement where we can dispense with the shareholders meeting and creditors meeting. Now the law only says creditors meeting can be dispensed with, but the section does not say, 230 clause 9 does not say, it doesn't use the word creditors or members, it only uses the word creditors. So this is going to be a problematic area where even if you have 5 shareholders, as per law we will have to hold meetings. Now how we develop law is different. When we go before the tribunal and then file, there are only 5 shareholders, use their inherent powers. I don't want to follow this process. Particularly there are also rules which say the NCLT can dispense with certain procedures contemplated or in the interest or what we call as the inherent powers of the tribunal in the interest of equity as what we call. So how we develop it later is different, but the reading of the law is that you cannot hold a members meeting. Then the mode of conduct of meeting, as I told you, regarding the postal ballot, we have to read it to the present SEBI circulars also. If it's a listed company, you will have to do a postal ballot or electronic voting. You can take it along with the provisions under the Act, which is 230 clause 4. But there is a vague wording too. When we read, we have to read all the 6 sections together, 230 to 236. I would request you to always bear in mind, because 237, 238, 239, 240 are completely only procedural ones. 230 to 236 is the law which completely governs this. Now 230 talks about majority, 230 clause 6, majority representing 3/4 in value, present and voting. So approval by postal ballot, we have been doing so also at the present. How many ever number of votes come, we treat it as present in person and get it as 3/4 in value. So majority calculated from the number of sheets we have received plus the 3/4 in value, we have no problem there. The important words which you'll have to continuously watch for all the sections is present and voting. Here luckily we have present and voting. In certain other sections where we go for fast track mergers as what we call, the present and voting is not there. And particularly when I come to another provision relating to who can object, the person present and present word is not there. The moment present word is not there, you will naturally have to calculate it only on the total capital. You end up saying that even if only 100, let's say 100 shareholders are there representing 60%, if I have to be a 10% objector, the 10% is not on the person's present.